Hi, good morning. Ted, for the record, could you let the public know why the meeting is a little bit delayed? You have people on Zoom with their hands raised. So just please clarify. Thank you. Hi, everyone. Can you guys hear us in room 101? Because Zoom cannot hear the presentation if it has kicked off. Zoom is muted.
Button? Is that a mute button?
We can hear you now. We can hear you now. Could the
What?
clerk also please turn on her camera for people on Zoom? Thank you.
Okay. I tell you what, since you did such a good job presenting, Jeff, I think it would be worthwhile for us to kind of summarize the meeting thus far for those who are on the Zoom and do the presentation again, if that's all right with you. We kind of go through it somewhat quickly, but, you know, given that Zoom is supposed to be as equally accessible as being in the room, I think we need to make sure that our technology is working and that we are, you know, providing access to folks. And so I just want to, for those of you who missed the Pledge of Allegiance, we'll let you skip that. But we had an item on public comment for those in attendance who wanted to provide public comment on items not on the agenda. Not this item, but other matters that are not on the agenda. If there's anyone on the Zoom who would like to provide such public comment, please raise your hand and identify yourself. Okay, then we can move on to the
We have two via Zoom, but this is prior to whenever you started.
yeah, well, that's why oh, and the hands are still raised.
Yes,
Okay,
we only have one now. Oh, now it's lowered.
all right, very good. So we'll move on to this item and I guess you need to reread it into the record because it wasn't, we're supposed to record this meeting for, you know, the folks who want to be able to see it later can't and or can't be here. So if you would, please introduce the item into the agenda.
We have item one, regular agenda. We have Code Compliance Officer John Bologna, owner PAG Partners LLC, appellant Tejinder Singh, file number VIO 2017-00054, location intersection of Miramar Avenue and Hermosa Avenue, APN number 048-076-120. And we are delayed due to technical difficulty.
Well, thanks very much, Ted. So, John, if you would please, can we, just take it from the top.
No problem. Good morning again, everyone. My name is John Bologna. I'm a senior code enforcement officer with the County of San Mateo. I will be presenting the fence violations at this property. That's Maria said, 0.8076-120, property owner TEG Partners. We received a complaint, the board received a complaint in 2017, a fence that was unpermitted being constructed on an undeveloped parcel. This is a portion of the fence as it's on the east side of the property line, and across here, the property line of the Coastside County Water District. Here is an aerial photo of the property. Right here is where the fence, the property line is the fence here, and across here with the water tank. And then it comes across here on the access road. No significant structure has been permitted on this 35,000 square foot undeveloped parcel in Overnight. The zoning for this property is R1, which is residential 1, DR district review, and CD coastal development, which brings me into my next slide and the basis of the slide. The subject property is in the coastal zone within the coastal development CD district overlay zone. All development in the coastal zone requires a coastal development permit, CDP, or a coastal development permit exemption, CDX. A CDX in this case was denied since the property is undeveloped and it does not meet the exemption criteria for maintenance, alteration, addition to a structure. The photo here is where the fence goes to the access road, and this is the property line that we showed. San Mateo County zoning regulations section 6328.3H, development. Means on land, in or underwater, the placement or erection of any solid material or structure. The construction of the fence within the structure is considered development. Here you see how the fence comes across the access road here, all the people of the property. San Mateo County zoning regulations, section 6328R. Project means any development as defined in section 6328.3H, as we just discussed, as well as any other permits or approvals required before the development may proceed. The construction of the fence is development, so therefore also the project. Section 6328.4, requirement for a coastal development company, establishes the requirement for a CDP for development in the CD district. Specifically, it states that any person, partnership, corporation, or state or local government agency wishing to undertake a project as defined in section 6328.3R of the CD district shall obtain a CDP in accordance with the provisions in this chapter. The section also allows that projects listed in section 6328.5 are exempt from requirement for a CDP. However, the subject fence is not eligible for a coastal development permit exemption. Okay. Since the property owner did not obtain a CDP prior to constructing the fence and has not applied for an after-the-fact CDP to legalize it, it's staff's determination that the fence is in violation of the zoning regulations section cited above. Staff recommends that the hearing officer uphold the administrative citation because the property owners are responsible for creating and maintaining the violation. The violation existed on September 8, 2021, and that's the date the administrative citation was issued. It continues to exist today. The decision issued by the hearing officer should include an administrative order to remove the fence within 30 days of the decision to deny the application to retain the fence, or within 30 days following the determination by the department that the required permits to construct the residence and retain the fence have not been diligently pursued, whichever comes first. Thank you.
Thank you, John. So now I would like to hear from the property owner, if the property owner is here. And or on the Zoom.
I have someone, I'm not sure if that is the property owner, Chowdhury.
I think he belongs, he's part of TDG partners.
He's part of the.
Then let's hear from Mr. or Ms.
Good
Chow.
Good morning. This is Mr. Chaudhary. I have been asked to appear for the sole purpose of reiterating my brother, Mr. TJ Singh's request and his attorney's request for continuance on the grounds stated in Mr. Solva, TJ's attorney letter. I have not have an interest in Take Partners LLC, and I am not authorized to appear at this hearing for any purpose other than the one I mentioned. I sincerely hope you agree you need to hear the other side also. Thank you.
Thank you, Mr. Chowdhury. So now I would like to open the public hearing, and we have one speaker slip, and it's from Ms. Ann Martin. And Ms. Martin, if you would please just to be at this, at the podium, please. And if you could keep your remarks to about 7 or 8 minutes, that would
Yes,
be
absolutely,
Yeah.
of course. Good morning, my name is Ann Martin. My husband and I have resided at 620 Miramar Drive for almost 12 years. And our home is across the street from the property owner's vacant parcel. I am here to strongly urge you to uphold the fence violation and follow planning staff's recommendation to order removal of the fence. Because this fence creates significant hazardous driving situation in our neighborhood, it's particularly important that it be ordered removed as soon as possible. Appellant has been afforded many opportunities to legalize this fence over the past 7 years, but has never done so. The only access to our neighborhood is via Miramar Drive, which is up a steep hill. And as you can see from the photos shown during Mr. Bologna's presentation, Miramar Drive, at the intersection of Hermosa and Miramar Drive, there's a fork, a western fork of Miramar Drive, going up to an eastern fork, going up to the water tank, the CCWD lot, and the easement driveway associated with 655 Miramar Drive. We like to call that portion of Miramar Drive Upper Miramar Drive, just for clarity. This is where the safety issue arises. When trucks and cars drive up to either the water company lot or the driveway access, they have difficulty turning around because of the unpermitted fence. The fence is installed on the boundary of the water company lot and on the boundary of the gravel driveway easement. And it makes it difficult and sometimes impossible for vehicles trying to exit the water company lot or the driveway to turn around safely. And as a result, a lot of these vehicles are forced to drive backwards down a rough, steep, ungraded hill, 231 feet, to the intersection of Miramar and Hermosa. This intersection is where vehicles and pedestrians are coming from 5 different directions, including people walking their dogs and the 5 young children who live in our neighborhood. If a car or a truck were to skid or lose control while driving backward down this steep hill, there could be. And this isn't a hypothetical. Around 2018, several sheriff's cars were called to the CCWD lot on a call. When one of the vehicles needed to leave, the driver was forced to drive backwards down Upper Miramar Drive because the fence precluded him safely turning around. He lost control of the car and demolished several mailboxes on the side of the road. Fortunately, another vehicle wasn't coming up Miramar Drive at the same time, but there could have been a tragic accident. In October of 2020, during the COVID lockdown, my neighbors and I started noticing how many vehicles were driving backwards down this road. And when we spoke to them, they indicated they were afraid to try to turn around up in the water company lot because of the fence and the steep cliff adjoining the water company lot. As a result, 9 neighbors sent a letter to Mary Rogan, director of CCWD, asking that she take action to rectify the dangerous driving of her employees. And she did take action. But that didn't fix the problem because there are many other drivers not associated with the water company who will reverse drive down Upper Miramar, either because their vehicles are too big to turn around, or they're afraid to try to turn around up there and risk driving off the edge of a steep cliff. Every time I drive up Miramar Drive, I never know if I'm going to be faced with some out-of-control vehicle driving backwards toward me down the hill. I have documented over the years over 60 instances of accidents, near accidents, and dangerous driving incidents caused by the unpermitted fence between October of 21 and December of 23. Since the beginning of 2024, there have been at least 7 instances of reverse driving, and yet another accident just last week involving a PG&E truck. And this brings me to the second danger. The fence makes it extremely difficult for large delivery vehicles to turn around onto the CCWD lot or the easement driveway. And this forces them onto this steep grassy median that leads down to Miramar Drive. This exposed steep cliff has no barrier to prevent vehicles from rolling or sliding down onto the street below where my neighbors and I walk and drive. I have witnessed and have sent videos to the county of several instances where large trucks have had their wheels partially off the cliff as they've gone off the road, trying to turn and navigate around this illegal fence. They're hanging over this denuded hillside, supported by a 20-foot retaining wall over our homes and over our road. Last Wednesday, a PG&E truck visited CCWD lot at 5:46 p.m. It had trouble turning around because of the fence, wound up getting stuck in the mud on the cliff above Lower Miramar Drive. A second PG&E truck appeared to come to its aid, and after about a half hour was ready to leave. It drove up the easement driveway to attempt to turn around, and as it was turning out of the easement driveway, it hit the fence yet again. I sent that video also to the planning department on Monday and to the zoning hearing officer yesterday. But just 2 days later, despite this latest accident, one of the property owners supervised repairs to the unpermitted fence. As the planning report makes clear, there's ample evidence that this violation has occurred and the property owner is responsible for causing and maintaining it. Further supported by the fact that each of the four times there has been an accident involving that fence, the property owners have promptly repaired it as recently as a week ago. The record shows the property owner, I'm wrapping up, has had many opportunities to legalize this fence and yet have never done so. I'm asking for the sake of the public safety of our community, of my family, and of the families in my neighborhood, that you uphold this violation and order the removal of the fence. Thank you.
Thank you, Ms. Martin. Is there anyone else from the public, or including on the Zoom meeting, would like to provide testimony regarding this permit for this violation?
I don't have any remote.
No. Okay, then I will close the public hearing. So as John noted in his presentation, this hearing is limited to consideration of the appeal of the violation. So, and the consideration is limited by the section 1.4 in the County Code of Regulations that limits my review to a determination of whether or not the violation existed, whether or not, and let's see here, let me just read it into the record. Only consider evidence is relevant to whether the violation occurred and whether the responsible person has caused or maintained the violation on the date specified in the administrative citation. So without any further input from, I have considered staff's presentation. The appellant has decided not to attend and provide any further comment on the matter. And we've heard from neighbors about the challenges associated with the fence. So it is my determination that I will uphold the citation and the administrative penalty, and that the fence shall be removed either within 30 days of a decision to deny an application to retain the fence, or within 30 days following a determination by the department that the required permits to construct the residence and retain the fence have not been diligently pursued, whichever comes first. And so that is my determination in this matter. You have a question?
I have Chowdhury. What do you think he's done again?
Well, Chowdhury said he didn't want to speak to the matter, but let's hear from Mr. Chowdhury. He asked for a continuance. I guess I should speak to that. There's no reason to. Go ahead, Mr. Chowdhury.
Yeah, I just want to make sure that, I was the comments I made. I think I heard you said that TJ, my brother, is not here or something. He already told the county that he's not in the town, and our lawyer sent a letter. So we are requesting a continuance, and it should be prudent and fair for all the aspects to be heard, and singularly giving an answer and judgment is something that I said that we would like you to, as I mentioned, I sincerely hope you agree. You need to hear the other side also. So we request continuation. That's what our lawyers did.
Thank you, Mr. Chowdhury. So we're not going to grant a continuance of this matter. It has been in process for over 6 years, nearly 7. The property owner has had ample opportunity to address this violation and has not done so, and has not made themselves available for this hearing. And I was made aware that the attorney couldn't be here, but I was not made aware that Mr. Singh could not be here. And so we've given ample opportunity and notice for Mr. Singh to attend and appear at this meeting either via Zoom or in person, and provide input as to whether or not the violation existed on the date specified in the citation. And so I'm sorry that Mr. Singh was unable to attend, but we're not going to grant a continuance in this matter. And thank you for your input, Mr. Chowdhury. And with that, I will adjourn the meeting because we have no other matters to discuss today. Thank you, everyone.